Yeah, especially.
You don't have to make
Alright, we're ready to go.
Yeah.
Contention 1, violence. Intimate partner violence continues unpunished. Reported Morrison, where the court ignored the economic impact of that violence marked in 2K. 3 out of every 4 women in the will be victims of violent crime. Crime is identified several links between violence against females and the national economy. Women are less likely to seek employment during even the overnight hours, as well as positions that are in data series. Victims of domestic violence more likely to be fired or put to work. Gender-motivated violence prohibits women participating in basic commercial activities. 50% of all homeless women and children without a place to live because they're fleeing domestic violence. Congress also has enumerated findings regarding the shortcomings of state law enforcement. 4 years out of congressional hearings, debate uncovered the national perception of crime is women as second class, not worthy of the attention of other violent crimes. And 1 out of every 100 domestic crimes that leads to an arrest and perpetrator have recently found 25% chance of being convicted. The average is minimizing the importance of gender-motivated violence. We said to the general public, Congress is trying to determine that the gender-motivated violence particularly affects interstate commerce and affecting women with full participation in day-to-day commercial activity. Congress views them as sufficient grounds to enacting the violence of rights under the Commerce Clause authority. More of this undervalued increases subordination of women within our society. Johnson, in 033, although women have less money, receive less compensation, systematic have their harms classified as non-economic. In consequence, such near in the Commerce Clause jurisprudence adversely disproportionately discriminatorily affects women. The Commerce Clause reinforces the magnitude of subordination further discriminatory within its analysis by holding Morrison that the intimate partner violence is less than a national effect in the production of home consumption and wheat, as in the Wicker decision. In court relegated the issue to the margin of ineffective local family solutions. McKinnon in 2K, the violence against women has remained in the Morrison court non-economic estimates, no matter what the economic cost or activity in Wicker. The activity pursued outside the stream of commerce to determine national growth for home consumption was found to found the regulation of the Commerce Clause to produce substantial economic effect. Women's productivity activity is so marginalized by the court that homebound growers in Egypt were more marginally engaged in the economic activity than women removed from the active role of national economy from sex-based violence. The discussion of the Commerce Clause repeated the discrimination sex-based is a local and outside the court's discussion of federalism, and the majority holding Morrison essentialized and devalued women to prevent the federal government from legislating equality for rights. And McKinnon in 2K, the Morrison majority found gender-motivated crimes violently affect Congress' power under the Commerce Clause. The court's economic essentialism devalued women. Material activity contributed to erase the documented financial loss caused by women in violation, narrowed the notion of economic certainty, and simplified the massive congressional record evidence of including gender-motivated violence affected the economic activity, including lost work, lost productivity, lost mobility, medical, and other expenses. And the court sent a message to Congress and society fundamentally denying equality for women in their progress, entrenched a script of self-blame for victims of intimate partner violence. Gleason in 2K, by ignoring the legislative history and giving literally no deference to the fact-finding legislative power to Congress, the Supreme Court silenced the voice of women while insulting them in the process. The Supreme Court has developed jurisprudence and considered legislative history only when convenient to defer to the power of Congress when it serves to subjugate women. The lawless serve to come as civil rights violations suffered women daily basis become subject to case decisions for terms of comfortable for men, economics, and power. Women once again taught the system devalues their input and effort, and this devaluation of women must effectively be challenged to protect human survival. Steen's an idea, but war, violence, and gender suppression all grow from the same root. The association of power, masculinity, virility, and very real consequences. The question is raised how we conceptualize the understanding not only violence, to say, but human survival may depend upon the linkage between death and masculinity. The redefinition of the political community for outside the idea of citizenship and doing so will confront the barracks community for that of the fear of the feminine, and the civil rights remedy sends a uniquely powerful signal to challenge social stereotypes that creates greater access to institutions to prevent domestic violence go far. And other civil rights are intrinsically assert they are demand to be heard, provides the potential for antidote for customary abuse. The victims of domestic violence should remain silent. Rights claims for women individually and as a group also have the capacity to change society as a whole by transforming the cultural frame of reference for civil rights provision and potentially counterpart the damaging belief federal civil rights guarantee historically been a uniquely powerful medium for communicating some sort of equality, opposition, discrimination by helping shift the social norm concerning the violence of women. Bottom civil rights provision was capable of altering sex discrimination attitudes, behavior, not only of private citizens, but also for official charge with responding to that violence. Contention 2 is economic citizenship. Holding and Morrison majority found that the opinions guaranteed that perpetuated the gender patterns of discrimination within our economy, reinforcing the subordination of women and denying them equal economic citizenship. Resonating 2K1. Had VAWA been sustained, the federal legislation power would have the available to redress the aspect of women inequality. If the court upheld VAWA civil rights, perhaps Congress would have the power to address discriminatory and alimony payment and compensation for labor, word, pension, material law, federal medical leave after Commerce Clause powers could thus only have the basis for Congress to experiment to alter the gender power within our economy. Constitution way of non-economic way into inside and outside the household. Women will depend upon household for physically security equal citizen will partake in a full range of economic and political activities. Under the majority of Morrison neither provides an accountable responsibility for decisions to stop federal legislation aimed at acknowledging female subordination inside and outside the household and the role that it plays in economic citizenship. And full concept of gender encompassing equality and citizenship is necessary for full citizenship for individual equality. This Kessel Harris knows in 07 economic citizenship I would include the right to work, occupation, and choice earning wages for support of the family, non-discriminatory job market, education, training, facility, access to the familiar economic citizenship resides in the state where when established women and men to participate within democratic polity to achieve full citizenship is continued with the political stance that management gender encompassing economic citizenship of the United States provides the most egregious example within the industrialized world, and citizenship as recognizing from protection from violence is critical to the establishment of individual agency. White and three, each citizen has a physical integrity, interest in having the effective power to draw some elementary boundaries between her physical self and other people. And the lack of power may develop in critical physical and psychological conditions for ethical agency. The ethical agency interest violated not only non-essential acts of aggression and interference with others, but also relationship with the individual vulnerable for accession or the discrimination against another. Moreover, increased democratization of the economy is vital for decision making that resists oppressive institutions. GJAC 99. So the point here is not to downplay the tremendous advance in favor of the return of some new version called the economic essentials. My point is rather the depolitization of the economy generates a new populist right, which is today the main obstacle to the realization of the very demands in which postmodern forms of political subjugation focus. The return to the privacy of the economy precisely because it creates a condition for a more effective realization of the feminist, ecological, and so on, demands a radical depolitization of the sphere of the economy. All talks about citizenship, about the political discussion, leading responsible collective decisions, so on to remain for these cultural issues. The one way of life difference, the only way to effectively bring about society which long-term decision would ensure the public debate involving all kinds of radical limitation of capital freedom is the radical repoliticization of the economy that increasing undermines the possibility of a proper political act, undermines indirectly due to the depolitization of economics and full participation in societal decision making is essential to avoid catastrophes as Bauman in 1999. The nation offers an escape for freedom, a situation where the public feels too cold and impersonal for self-assurance. The responsibility for public life meaning too onerous to carry the democratization is perhaps the incidental toothlessness and impact and guide for the conditions that are vital of the system. They're not one but several icebergs, each one referring more technical than the last. There's a financial iceberg, on currency speculation, the nuclear iceberg, there's ecological iceberg, there are the social iceberg with 3 billion men and women effectively made redundant, devoid of economic function during the lifespan of political generation. The realization of each one of the icebergs is not say they won the strength of the hand, with no one left for the film to eventually write the epic or lyrical verses about the mayhem that ensued. Thus, the plan of the United States Supreme Court should overrule U.S. v. Morrison decision holding that in accordance with congressional fact-finding gender balance has a substantial effect on interstate commerce. Contention for us all, and see the Supreme Court overrules Morrison and acts legal recognition that will immediately erase discrimination against women. Johnson in 03, the Supreme Court needs to take steps to remedy discrimination and prevent reinforce was the existing discrimination. The first step in the uncovered system where privilege recognizing human and their harm is very dangerous. System privilege are elusive, providing the right and power for their invisibility. The judge also needs the judicial commitment to end sex discrimination against women. The standpoint of the Commerce Clause is a starting point. Was precedent maintained without strain reading. The court applied to Morrison. The court must give some weight to the congressional findings. The court must aim for stronger recognition on women's true role in commerce and market without properly evaluation of women's or recognition of economic impact of violence against women. If the legal system places articulate values on the rules, discrimination will automatically cease to exist. And overruling Morrison, the Commerce Clause is essential to provide the economic valuation of women necessary for the true equality resting. And one, violence against women should not be inclined to the nature of activity and economic nature is painfully ironic. Women once should alter economic nature as species of property. Yet when women seek to be holders and producers of property players in the market, thinking about women in economic terms have claimed to be a category A. The strategic reason why Ball relied on commerce from powers is understood by framing the problem of violence against women is embedded within commerce provision, descriptive and normative accuracy about the degree in which the current economy has formulated gender allocations for subordination of women. Obtaining equality to women may depend on gaining recognition as commercial actors, and substantial economic equality represents an independent demand for justice. White in 03, perhaps the equalization acts is ultimately managed on the reciprocity for its own sake. Reciprocity in the view is not an axiom, but just a more theorem derives from some form of co-equal economic axiom. The substantial economic reciprocity in some forms of equality is not undeniable. The case seems to me ultimately stays an independent demand for justice, primary virtue of its sheer relativity within its own right, and alternatives that are not federal government and not federal, that has created a script of self-blame by the victims who must engage the government at the federal level to have the most effective see reducing violence. Schneider in 95, the power to stop violence begins with me. The slogan ignores the responsibility of government to declare violence against women. The public problem reinforcing historically gives domestic violence and privacy, emphasizing individual solution to individual and perhaps inadvertently individual self-blame at the expense of collective action. Government has the power, responsibility, and authority to transfer social institution of reason that ensures safety. This slogan will emphasize the importance of individual action and preferably funds the privatization of the solution to the social level. Unless we turn the historically higher problem to a public problem at every level of government, and the acts of reconceptualization will not begin realizing prevention, safety, and resources for battered women. Right, reconceptualization, importance of women, more strategy that may properly engage government to more directly make this process of reconceptualization against battered women. Our constitutional commitment to equality and justice under the law obliges to ensure equal economic citizenship. West in 05, there's nothing that the court should do, everything that they must do. Women as human beings must be treated such representing the ethically unstable claim to the fact that women are barred so unjustly ethical that the main mandate the women must live their life and work along the rule of justice. And the courts must be the vehicle of justice, and they must ensure delivery of the court of the justice demanded. Law must engage in process, and the court must deliver it.
Okay. First question. You make a number of arguments about the court's jurisprudence and why it's devaluing women and the Congress and all these things. I guess I'm just not sure, like, why, I mean, what evidence do you have that says Congress will automatically start changing discrimination, or evidence cites the ERISA, it cites all these things that could happen, but why would Congress ever do these things?
Well, our argument would be that this creates a green lighting for progressive social legislation. The Democrats within the House now probably would be able to address this. The argument that it would be politically successful in some different attempts to be able to address violence.
So is it more than that? Because you seem to read like maybe 1 or 2 cards about the civil remedy being good, right? I'm wondering, is it the signal that's important? Is it the congressional future legislation that's important? Is it the act of suing that's important? Which one is it?
Well, our argument is that all of these things are important, that there are 3 parts to our affirmative. The first one is that the civil remedy has a means of deterring domestic violence.
Okay.
The second part is that the green lighting of legislation has the ability to further address women's economic essentialism within the economy. And the third one is that our Johnson evidence indicates that the language the court itself used for devaluing women's activity, and women and men,
Okay,
all
now we're on, yeah, agree. Let's talk about this court I don't get what this court's anti-discrimination jurisprudence is. A lot of your Johnson evidence talks about it. I think your Resnick and Kessler and Harriet's evidence talks about the importance of this jurisprudence of the court that's just so opposed to women. I don't know what
Yeah, our
this is
McKinnon
arguing.
evidence indicates that the court decided in the Wicker decision that if you grow wheat and you have no intention of selling it, but you
No,
eat it,
I mean, I get the
then you
Wicker
have-
decision. I don't need to hear about that. I want to talk about
Well-
this jurisprudence.
Well, yeah, it's the argument that we cannot, when the court decides that homegrown eaters of wheat are regulation of the Commerce Clause, but that intimate partner violence and domestic violence cannot be regulated by the economy, it sends the signal that the way in which we recognize violence within society is not valued when
And
it
so
comes to domestic
it's this
violence.
jurisprudence that the court has that's so messed up, right? That it treats women as not citizens.
It is not just like the regulations that the court has created, it is also the language itself that the court needs to be able to confront the
So
almost
it's-
mistake that they have made.
I think so the language that the court is using in response to gender concerns is important, correct?
In the language of the
Okay,
decision.
one more question. You read a card about why only federal action is critical and individual alternatives fail. Saying of this as civil remedy forces women to sue on their own through an individual basis. Why doesn't this link more to the affirmative?
No, the Schneider evidence is not about, well, individuals is bad. It's saying that when individuals say that we should not turn to the government or that there are alternatives and that the government is
How
always
do you turn to the
bad.
government? You have people sue each other.
Exactly. Therefore, the government is forced to confront a public problem, and the government recognizes violence as a public problem and not merely a private problem. When we leave solutions in the private and ignore the role the government has in creating domestic violence as a private problem, then it only facilitates the script of self-blame.
Dig it.
Okay,